Last year, 40% of fired workers had grounds to sue for wrongful termination, but never did, because they thought at will meant powerless. Ever wonder what at will employment actually protects your boss from and where it stops? Today, I'll explain wrongful termination versus at will employment like you're 5. By the end, you'll know exactly when you can fight back and which protections most people don't realize exist. Quick note, this is legal education, not legal advice. Employment laws vary by state, so if you're facing termination, talk to an employment attorney in your area. Here's the thing. Most people think at-will employment means you're completely screwed. Boss doesn't like your haircut, and you're fired. Boss woke up grumpy, and you're fired. Boss just feels like it, and you're fired. And technically, that's sort of true. At-will means your employer can end your job without warning. They don't need a reason, and they don't need to do a performance review. You can also quit whenever you want. No 2 weeks notice required. It goes both ways, like a friendship where either person can walk away. You don't owe your friend a formal breakup letter. They don't need to file paperwork to stop hanging out with you. That's at will. Sounds simple, right? But here's where everyone gets it wrong. At will doesn't mean anything goes whatsoever. There are massive, lawsuit-sized exceptions carved out. Your boss can fire you for almost any reason, but not every reason. The difference between those two things is where wrongful termination lives. So what actually makes a termination wrongful? Let me give you the big 5 protections. These are federal protections that apply in every state, whether you're at will or not. First one is discrimination based on protected classes. Your boss fires you because of your race, color, religion, sex, national origin, age over 40, disability, or genetic information. All illegal. Doesn't matter if you're at will or if they phrase it nicely. If the real reason is one of those things, that's wrongful termination. Here's the tricky part. Your boss probably won't say it out loud. They're not going to hand you a termination letter that says fired for being too old. They'll say budget cuts, restructuring, performance issues. But if you can prove the real reason was your age, you've got a case. It's like getting pulled over. The cop says you were speeding. But if you can prove they only pulled you over because of your skin color, that's a civil rights violation. Second exception is retaliation. You reported harassment. You filed a workers' comp claim. You complained about unsafe conditions or wage theft. Then suddenly you're fired for being 2 minutes late. That's retaliation. The law calls it adverse action. Basically, your employer punished you for doing something you're legally allowed to do. Imagine you tell the health inspector your restaurant has rats. The next day, your boss cuts your hours in half. Same idea. You did the right thing. They made your life worse because of it. Illegal in all 50 states. Third one is refusing to do something illegal. Your boss tells you to lie to a client, forge a document, drive a truck you know isn't safe. You say no. They fire you. That's called wrongful termination in violation of public policy. Sounds fancy. It just means your employer can't fire you for refusing to break the law. It's like your friend asking you to shoplift, then getting mad when you won't. Except here, your employer is the one facing consequences. Before I show you the 4th exception, let me explain why companies get away with this so often. It's the same reason landlords win most evictions. Most employees never fight back. They assume at will means powerless. They don't know these exceptions exist, so they take the severance, sign the release, and walk away. That's exactly what your employer is counting on. 4th exception is union and labor organizing. You talk to coworkers about pay. You try to form a union. You complain about working conditions as a group. Federal law protects that. It's called the National Labor Relations Act. Your boss fires you for organizing? Wrongful termination. And here's the part that surprises people. You don't need an actual union. Just talking to coworkers about wages is protected. You and your coworker compare paychecks and realize she's getting paid less for the same job. You talk about it, your boss finds out, and fires both of you. Illegal. The law protects concerted activity. Basically, employees banding together. Your boss wants you to think you're all isolated. The second you start talking to each other, their power shrinks. 5th exception is whistleblowing. You report fraud, safety violations, or illegal activity to a government agency. Then you get fired. In most cases, that's wrongful termination. Federal laws like Sarbanes-Oxley and the Dodd-Frank Act protect whistleblowers in specific industries. Some states have their own protections that go even further. Think of it like this. The government wants people to report corruption. If your boss could just fire you for it, nobody would ever speak up, so they made it illegal to retaliate. Now here's the part nobody tells you. Even if your termination falls into one of these categories, you still have to prove it. And your employer knows that. They'll have a paper trail. Performance reviews that suddenly went downhill. Write-ups for being late. Documented complaints from coworkers. All of it created after you filed that complaint, or turned 40, or requested medical leave. It's called building a pretextual record. Basically, your boss is creating a fake reason to cover up the real one. Imagine you're playing a card game. You've got a winning hand, but your opponent swaps out one of your cards when you're not looking. You know something's wrong. But proving it? That's harder. So how do you actually prove wrongful termination? You look for patterns. Did they fire 3 people over 50 in 6 months and replace them all with 25-year-olds? Pattern. Did you file a sexual harassment complaint and get fired 2 weeks later after 5 years of great reviews? Timeline. Did your boss send an email joking about your disability right before your termination? Smoking gun. Employment lawyers look for these things. Timing is huge. If you complained on Monday and got fired on Friday, that's not a coincidence. Courts call it temporal proximity. Fancy words for that's suspicious as hell. Let me give you a real example. Keisha works in accounting. She's 48, she's been there 6 years. Solid reviews, no issues. She notices her boss is fudging numbers on a government contract. She reports it to HR. 3 weeks later, she gets written up for missing a deadline. 2 weeks after that, another write-up for being difficult to work with. A month later, she's fired for poor performance. At will state. Her boss says she just wasn't cutting it anymore. But Keisha kept emails. She has her old reviews. She can show that every write-up happened after she reported the fraud. She talks to an employment attorney. They file a wrongful termination suit for retaliation. Her employer settles before trial. Keisha gets back pay, damages, and attorney fees. Her boss thought at will meant untouchable. Turns out, it didn't. Here's what most people miss about these protections. They work even when your boss is clever about hiding the real reason. Your employer will rarely admit discrimination or retaliation. They'll manufacture a legitimate-sounding excuse. But courts aren't stupid. They look at context. They look at timing. They look at whether your treatment changed after you became a protected person or did a protected action. The burden of proof starts with you. You have to show that it's more likely than not that discrimination or retaliation was the reason. But once you meet that burden, it shifts. Your employer has to prove they would have fired you anyway. And if their excuse falls apart, you win. That's why documentation matters so much. Save your performance reviews. Screenshot compliments from your boss. Keep emails showing you met deadlines. If your treatment suddenly changes after you report something or hit a certain age, document the shift. Write down dates and what happened. Note who was present. Most wrongful termination cases don't go to trial. They settle. Your employer doesn't want discovery. They don't want their emails read in court. They don't want former employees testifying about patterns. So they offer money to make it go away. But you only get that leverage if you can show you have a case worth fighting. If you're watching this because you just got fired, here's what you do. Write down everything. Dates, emails, conversations, witnesses. If you reported something and then got fired, document the timeline. If you're over 40 and got replaced by someone 20 years younger, note it. Then talk to an employment attorney. Most offer free consultations. They'll tell you if you have a case. You don't need to be sure. You just need to ask. At will is the rule, wrongful termination is the exception. But the exceptions are bigger than most people think. Discrimination, retaliation, refusing illegal orders, union activity, and whistleblowing are all carved out. Your employer wanted you to think at will meant powerless. It doesn't. It just means you have to know where the line is. Hit subscribe if this helped you see your rights differently. Now, here's my question. Have you ever been fired for something that felt illegal, but you didn't fight it because you assumed at will meant you had no chance? Drop a comment. Your story might help someone else recognize what happened to them.